Good afternoon, ladies and gentlemen. Dr. 𝐒𝐞𝐫 𝐑𝐨𝐫 General Secretary, other respected members of the dais, teachers, faculty, and most of all, the students. It is my pleasure to be here with you this afternoon to hand out the certificates and prizes in this valedictory session. I will not take too long, as I know that when you're sitting on that side, you don't like the guy who's standing here and continuing on and on for a very long time. I'll keep it short. I just want to talk to you about two things today. One is the very important theme that is there for this festival and this conference, which is transparency and accountability in justice administration, challenges and solutions. That will be a very small part. What I want to talk to you more about is your transition from where you are today, because I think the central focus of any festival such as this are the students. So I want to give you my experience or my advice, unsolicited, but for your transition from this phase into the next. Insofar as the theme is concerned, there has been much debate, much discussion, and much evolution of transparency and accountability in our judicial system. We all remember beginning of last year when a few judges of the Honorable Supreme Court decided to hold a press conference to talk about certain things which have obviously been plaguing our system and something which has not been addressed as adequately as it should have been in their minds. Transparency, accountability, fairness. To my mind, the harmony of these three are the bedrock of our judicial system. Without these, our judiciary, which is robust and independent today, would not survive. And I think that in a country like ours, which has always had a very strong and dominant executive, the judiciary has always played more than its part and often not been given its due. Insofar as transparency is concerned, there is always a paradox between transparency, accountability, and independence. Typically, accountability would mean that you as an individual or as a judge or as a lawyer or as an institution would be accountable for certain actions that you do. That, when juxtaposed with independence, is a very thin line which has to be maintained in order to care for the judicial independence, which is again a bedrock and part of the basic structure of our constitution. If you look at transparency, I think as a nation, as even globally, transparency has become more of a norm today than it was maybe 10, 15 or 30 years ago. A lot in our country is to do with the Right to Information Act, which actually allows individuals, corporates, entities to get information on certain proposals, certain files of theirs that remain pending with government departments. And they are no longer at the mercy of these bureaucrats who may or may not decide to divulge certain information. On the other hand, you have the judgment of the Supreme Court saying that the right to privacy is a fundamental right. So there, again, there is an element of transparency which is ingrained in privacy. And there will be elements of privacy which may not be transparent as it should be. While others may argue that everything should be transparent, especially when it comes to judges, when it comes to our judicial system. I believe that the Supreme Court has taken a very bold step by setting the procedure for putting up collegium resolutions with regard to those individuals that apply to become judges, or those individuals who have been selected, or those that have not been selected. Naturally, I think there are many things that need to be tweaked, that need to be worked upon, but it is a way forward. Till now, we've never had a system where anybody knows why a judge is selected, not selected, who's being selected, and how many have been bypassed, not bypassed. At least with this, our society, every person concerned, has some information as to whether things are happening in a particular format, what is in the minds of the judges, which was otherwise and continues to be a closed room of judges sitting physically in a room, and we don't know what deliberations happen except these resolutions. Insofar as the challenges are concerned to this, I would say that an individual whose name has been proposed for judgeship, if he does not get selected, take a case of a very good lawyer in the High Court, for example, whose name is proposed as a High Court judge. The Supreme Court considers the name and thereafter says we find him unfit to become a judge. Now, that is a scenario where there is no face-to-face hearing with that candidate of the collegium. And tomorrow, the candidate will always be left with a question mark that what was lacking in his personality that he didn't become a judge. And otherwise, he's a great lawyer, a busy lawyer, and well-respected individual. So I feel it's a real pleasure to see this lovely college, and I wish you all the best for the prizes and certificates. But really speaking, prizes and certificates are not the only barometer of whether you are good or bad. Like marks are not the only barometer. So never let these things either get you too high or walk you down. And yes, best of luck. Thank you.